Well, hello there and welcome once again to the Employment Law Show. John Scholes along with Lior Samfiru, still doing the physical distancing, so we're in our respective studios, but ready to give you all the information that you do need. Anyway, if you've never caught our show before, we talk, of course, about employment law, whether you're an employee or an employer. This is the law that matters to you. It's where you spend most of your time anyway, at least when you're back to work on a normal schedule. So you really got to know the ins and outs of the employment law, the common law, as it pertains to what you do every day. So every week we endeavor to fill you in and expand your mind with the knowledge of employment law. So we're going to get right to it. Reaching out anytime, by the way, 1-855-821-5900, help at employmentlawyer.ca. Coming up on the show today, we're going to talk about answers to common employment law questions. There you go. Bread and butter show. But first, the week that was, pal. How are you?
John, great to be back here. Great to be talking about employment law. And for those that are watching us for the first time, we are here to talk about workplace rights, your rights on the job. If you have a job, lost your job, are on a layoff, something happened, maybe you're being mistreated in the workplace or your job has changed. This is the show. Every week we talk about those things and more. So if you have a question about workplace rights, we'll try to cover as many topics on this show as possible. But of course, you may have a question or a situation that we're not addressing. Not a problem. We'll give you my contact information throughout the show. You can call, you can email. Happy to chat with you and answer and hopefully solve your workplace problem. That's the name of the game. I'm not just here on TV to talk. When I'm not on TV, I actually help resolve and do solve these workplace problems. So take advantage of that. But week there was, every week I like to talk about the situation that came across my desk over the past few days. So earlier in the week, I spoke with a lady who was on a temporary layoff because of COVID-19 and was recalled back to work. But when she was called back to work, her employer said, we're gonna have a very different job for you. In fact, we're gonna put you in a sales role. She had never done sales before, didn't want to do sales, didn't know how to do sales, and told her employer, no, I'm not interested. That's not me. I just want to do my old regular job. Well, what her employer said to her, well, no, you have two choices, really. You can either accept this new job, this sales job, or you can just submit your resignation. And that's when she called me. And she said, wait a second, I don't want to resign. I just want my old job back. What gives here? So here's the thing, John. First of all, we're going to be talking about this more later, the idea that an employer does not have a right to change the terms of your employment in a significant way. Whether it's COVID-19 related or not, your employer does not have a right to make such significant changes. And certainly, taking someone and putting her in a brand new position, a sales role, is a significant change. Your employer doesn't have a right to do that. And if you refuse to accept that, that's not a resignation. Remember, the only one that can decide if you resign is you. You can never be told you have to resign. The moment you're told you have to resign, that becomes a termination. The only one that can decide that, it has to be you, and it has to be a decision that you make unilaterally yourself. There's no such thing as a forced resignation. So what does this mean for this lady? If she doesn't accept and her employer insists on putting her in that role anyway, that becomes what we call a constructive dismissal. They've effectively terminated her employment and they must pay severance. So you may be in a similar situation coming back from a layoff. Maybe your job has changed. Maybe the compensation has changed. Your employer says we're going to pay you 50% or 75%. Remember, even if it's COVID-19 related, your employer does not have a right to make significant changes to terms of employment. If they do, that could be treated by you, if you want it to be, as a constructive dismissal, meaning you're going to be owed your full severance.
If there's other ways for you to reach out anytime, you can go to employmentlawyer.ca. That is the website. Also, pocketemploymentlawyer.ca. This is an amazing website. It's absolutely free of charge. It's anonymous. There is a contact at the top through email or phone call or otherwise, but there is tons of information and lots on COVID-19 as well. But employmentlawyer.ca, the website, the firm website, is where you want to go to catch a station where you can catch our radio show and our TV show as well, past episodes of this. Lior, we like to get back to the radio show sometimes, which we've been doing for 8.5, 9 years, I think, pretty close to that time anyway. We play some of the good calls we get on the radio show here and we talk about them. So the first call for the day is coming up right now.
I had an argument with some friends of ours. My wife's been laid off her job as a dental assistant. She was with the guy for 30 years, and they told me the max you can get is 2 weeks severance.
How long ago did this happen?
Well, just about 7 weeks ago now.
Wow.
Wow. Yeah, wow is right. Really, that's all you can say here. This is a prime example. This is a call we got on one of our radio shows where someone was working for 30 years, let go, and is being told 2 weeks is all you get. Nonsense. Well, here's the thing. Some of our non-regular viewers may realize that it's more than 2 weeks, but they may think, well, maybe it's 2 months or 3 months or 4 months. Here's the thing. That's wrong. Remember, your entitlements, if you lost your job, it's not capped at a week per year or anything like that. Your entitlements are based on 3 factors: your age, your position, and the length of your employment. So the longer you work, the older you are, and the more senior a position you have, the more severance is owed to you. And that means significant amount of severance. Now, we have a tool that we created. It's called pocketemploymentlawyer.ca. We'll talk about that more in a second. That allows you to find out how much severance you're actually owed. So I'm going to spoil it for you before we even use the pocketemploymentlawyer.ca. She's owed 24 months' pay. But let's actually go through that analysis on pocketemploymentlawyer.ca. So we input that information you see on the screen. So she's 63 years old, dental assistant for 30 years employed. And you see right at the bottom, the calculation correctly shows she's owed 24 months' pay. 24 months' pay. She was told 2 weeks is all she gets. Nonsense. 24 months' pay. Now, you may have only worked for an employer for a lot less than 30 years, maybe for a year, maybe for 2. But even for you, your entitlements are going to be calculated in the months, not the weeks, in the months. So very, very important to get that legal advice, or go to pocketemploymentlawyer.ca if you lost your job, to make sure that you don't accept inadequate severance.
Yep, pocketemploymentlawyer.ca is the place to go. You can also reach out there through email as well. I want to get to one of those, Lior. This one comes in from Stacy. Says, my boss just told me that they are closing their Toronto office and moving all jobs to Vancouver, across the country. I've been working in Toronto for the last 11 years. Can they do that? If I refuse, will it be seen as a resignation?
Well, you know, last time I looked at my atlas, Toronto and Vancouver were pretty far apart.
Yeah.
So that is a massive change. Frankly, even if they were moving an hour down the road, that would also be something that an employer is not allowed to do. But to move cross-country, no, she does not have to accept. For obvious reasons, she's not going to accept. But that's not a resignation. We talked about that before the beginning of the show. She's not resigning. She simply can't do that, and an employer can't make her do it. So what does this mean? That move from Toronto to Vancouver becomes a termination. She doesn't have to accept that, of course. Her employment is then, the law deems it to be termination, and she's owed severance. Very simple, very easy to figure that out. And by the way, even if your employer moves, you know, my general rule is about an hour. If your commute is increasing by about an hour a day because of a move-in location, usually that's not something an employer can do, and you have the right to treat that as a constructive dismissal. I mentioned pocketemploymentlawyer.ca before. We also have a tool in pocketemploymentlawyer.ca to find out if, in fact, your job has been constructively terminated, if you're in a constructive dismissal situation. So always check out pocketemploymentlawyer.ca.
You know, it's funny you mentioned that hour increase in time, and that is exactly it. It could just be time. It could be a matter of not that much distance, but now you got to take 2 more buses to get to and from work, and it could be an hour. That could be enough, right? Oh,
absolutely. I've spoken with people who don't drive, you know, to take public transportation. They were working and living 5 minutes from work. Now the job has changed. They moved location. Now, because they don't drive, they have to take public transportation. It's going to take them an hour and a half to get there instead of 5 minutes. Well, that is a massive change. So even though the physical distance of the move is not that significant, the time it takes you is really what matters. So if you're now having to commute more than an hour, more than you did before because your workplace changed locations, that could absolutely be a constructive dismissal.
All right, coming up here, answers to common employment law questions. That is on the way, so stick around for it. In the meantime, as we go to break here, 1-855-821-5900 and help@employmentlawyer.ca is the email address. We'll get to that in the Employment Law Show. Stick around.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They said they had a good reason. but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
All right, welcome back. Employment Law Show. John Scholes, Lior Samfiru. If you're just joining us, we're talking about employment law, hence the title of the show. You need to know this stuff because a lot of us work 8, 9, 10 hours a day, 5 days a week or more. So you got to know where you stand when it comes to the common law. So answers to common employment law questions. Let's get right into these, Lior. Number one is this: can my employer lay me off if I didn't do anything wrong?
And that is a very, very common question that I get. Usually when someone loses their job, the first thing that they want to talk to me about is the fact that they just don't feel that it was right, that they don't feel that the company had the ability to make that decision. Why should I be let go if I did nothing wrong? And here's where a lot of people get surprised by my answer. And the answer is that, unfortunately, the law is such that an employer can let you go at any time and pretty much for any reason, as long as they pay full severance. So you may have done nothing wrong at all, or maybe the company lets you go because they want to hire someone else and pay them less. That may make them not good people or not very nice, but legally an employer can do that as long as they pay you proper severance. Now, we've heard this term wrongful dismissal. A wrongful dismissal really is a situation where you've been let go and have not been paid proper severance. So generally speaking, the reason doesn't factor in. It's a question of severance. Now, there are some exceptions. You cannot be let go for discriminatory reasons, for example. You cannot be let go because of your age or ethnicity or disability or sexual orientation. That would be illegal. Doesn't matter how much severance is paid. You also can't be let go because you're trying to stand up for your legal rights if you, for example, complain about harassment. But generally speaking, your employer can let you go. It's a question of severance. But remember, severance can be significant. We could be talking tens of thousands of dollars that you're legally owed. So even though the reason might not matter, the severance definitely does.
We're talking about very common employment law questions you get literally day in, day out of the firm, right across all the different offices that you keep. Next one is this: what is a fair severance package and how much should I get? I'm thinking it is not 2 weeks for 30 years work like we had in the first segment.
Really? It's not? No. So you're right. We talked about the fact that you can be let go at any time as long as you get paid severance. So the next question, the next logical question, well, okay, fine. Well, how much severance do I get? Well, the unfortunate thing is I can't tell you this is the rule, this is the formula, because there's no direct formula. It depends on your age and your position and the length of your employment, as I was mentioning earlier. So no two situations are alike. But here's what it's not. It's not a week per year. It's not 2 weeks per year. It's significantly more than that. The other thing I will say is that short service employees, employees with 3 years seniority or less, are actually treated disproportionately better than longer service employees. So you may have only worked for a company for a year. You could be owed 6 months' pay. You could have only worked for 6 months and still be owed 6 months' pay if your position is senior enough and depending on your age. So short service doesn't mean little severance. But rather than just kind of figure it out or guess what you're owed, you can find out in seconds. I mentioned it earlier. Just go to pocketemploymentlawyer.ca. There's a severance calculator feature there. It's free. It's anonymous. It takes seconds. If you have ever just been curious about, hey, what would I be owed if I lost my job? Just go to pocketemploymentlawyer.ca. Don't wander anymore. Find out. And if you know someone else that's been let go, your friend, your neighbor, your family member, tell them before they even think of signing off on that severance letter, go to pocketemploymentlawyer.ca.
I know another common question you get all the time, Lior, you and the staff, is, can my employer put a time limit on my offer? That Friday at 5, you have to have this signed and back to us, right?
Every single severance letter, everyone has a deadline. So your employer is going to say, hey, we're going to pay you this amount of money, but to accept it, you have to sign by Friday at 5, Tuesday at 5, whatever that date is. And that's a pressure tactic. Oh my God, I better sign this or I'm not going to get this money. Nonsense. All it is a pressure tactic. 90% of cases, and over 90% of cases, when people are let go, they're not offered even close to what they're actually owed. Not even close. So think about this situation. Let's say you're owed 18 months' pay. Your employer says, I'm going to pay you 6 months' pay, but you better sign by Friday. wait a second, you owe me 18 months pay. Forget about Friday, forget about 6 months. That's why it's so important to determine how much you're actually owed. John, every single day I speak with people who find out about me, find out about my law firm once it's too late, once they've signed off on that severance letter, and they may realize, holy cow, I was owed another year's pay. Can't do anything about that, unfortunately. So that deadline is a pressure tactic. It means nothing. Your legal rights don't expire Friday at 5. You have 2 years to pursue your legal rights. Ignore that deadline. Make sure you know how much you're owed. Get proper advice. PocketEmploymentLawyer.ca is your friend. Happy to talk to you anytime.
We're talking about some of the more common questions you get day in, day out on the phone or otherwise in person, an email at the firm. Another one is this: an employer wants to make a big change in my job. How do I stop them?
So this is a very common situation. Your employer wants to change your role, your responsibilities, your pay, your bonus structure, and well, how do I stop it? The unfortunate answer is that there's actually no way to physically stop an employer from changing terms of employment. Now, it's not legal. It's not legal for an employer to change terms of employment, but there's still no way to actually stop it. So what happens is if you're faced with a significant change to terms of employment, you have a choice to make. You can choose to accept the change, of course, and continue working, or you can choose to treat that change as a constructive dismissal, a termination, and get your severance. Now, one of the reasons you may want to consider constructive dismissal is this: if you're simply going to accept that change because you want to be the good soldier or you're concerned about pursuing constructive dismissal, by accepting that change, you've given the company the right to do it again. So you may have now only taken a 15% pay cut, and you think, well, I'll live with it, I'm not happy, but I'll continue. But by accepting that 15% pay cut, you've given the company the right to do it again. And next time, if it's another 15% or 20 or 50%, you won't be able to do anything about it. That's why it's so important when your job starts changing to stand up for your rights and not just accept them. It's just an invitation for more changes down the road.
Reaching out, by the way, anytime, as you know, 1-855-821-5900, help@employmentlawyer.ca, talking about some of the more common questions you get at the firm every day and every week. Another one is, I'm being harassed at work, Lior. What can I do about it?
Workplace harassment is unacceptable. We all have a right to work in a harassment-free work environment. Full stop. That's a fundamental right that we all have. Now, if you are being harassed, the thing you should be doing is letting your employer know and trying to get them to resolve it. Your employer has to deal with it, has to investigate, and has to take measures to rectify the situation, to eliminate the harassment. Now, that's your first recourse. If you're a victim of harassment, give the company the chance to fix the problem. Talk to HR, talk to someone in charge. Make sure there's a record of that in writing, that you did that you spoke to them. If nothing happens or there's no one to talk to, then you reach out to me. Then we deal with it externally, and we could potentially get you out of there and get you compensation. So first step with workplace harassment, deal with it internally. Keep a record of it. If that's failed, or there's no opportunity or possibility to deal with it internally, let's deal with it externally. Reach out to me and let's figure it out. But workplace harassment, John, is completely unacceptable.
If it's a situation where it's a smaller workplace and maybe the person you should be reporting to is the one doing the harassing, now what do you do?
Well, that is a classic example of having to deal with it externally. If the owner of the company is the one harassing you, well, who are you going to talk to? There's no one above that person. In that situation, we have to deal with it externally. In that case, we have to then get you out of there. The fact that you've had to endure harassment means that you can get out of that workplace with compensation, and you really want to do something about it. I've spoken with dozens and dozens, if not hundreds of people over the years, where because of workplace harassment, they didn't do anything about it. They ended up going on a disability leave. It's impacted their health and their family. Not a good idea. Let's deal with it head on. The law does protect you if you're a victim of workplace harassment.
Get to one more here on the list of common employment law questions you get all the time. And this one is, I'm still on a temporary layoff over here, Lior. Does my company, does my employer eventually have to recall me back at some time?
Well, our regular viewers know this, but we have new viewers all the time. The temporary layoff is likely illegal to begin with. Your employer does not have a right to lay you off temporarily, even if it's COVID-19 related or for any other reason. There's no right to do that, meaning you can treat that layoff right off the bat on day one as a termination of your employment and get severance. Now, if you choose not to do that, if you choose to accept the layoff and stay home and see what happens, yes, you have to get recalled back or it does become a termination again. Now, depending where you are, in BC, for example, the layoff can last 16 weeks. Right now in Ontario, it could be 13 weeks. So if you're not called back within that period of time, that becomes a termination and severance has to be paid. So you can treat that right away as a termination, get severance now, or wait to see what happens. If you don't get called back to work, yes, your employer absolutely must pay you severance.
EmploymentLawyer.ca, that is the website. You can find archives of this show and the radio show as well. Also find a radio station across the country that carries the show you can listen to on a weekly basis. We take phone calls from those radio shows and we play them back and dissect them. I guess you could say phone call number 2 for the day is coming up right now.
My son is a second-year university student. He had a summer job last year, beginning of May until the end of August. It's a 2-year contract, so he was supposed to go back this May, but they have terminated the arrangement. Would he be able to apply for the CERB? He did earn more than $5,000 last summer.
Mm-hmm. So there's actually a couple of issues here. Before we even talk about the CERB, let's talk about what happens if his employment is terminated. He had a job and now he doesn't have that job. Well, if he has already been an employee, then severance again has to be paid. And if he had a contract, let's say, that went from, I don't know, for May till October, then that over that 5 or 6 month period, if that contract now doesn't exist, the company actually has to pay him for the balance of the contract. Remember, this is an important thing for everyone to know. If you're working on a fixed term, so for 6 months, 12 months, some fixed amount of time, if your employer ends that relationship before the end of the term, they still have to pay you for the balance of that term, whether it's a month or 6 months or 20 months. So that's important to remember. So in terms of CERB, yes, you absolutely would be owed CERB in that situation because you had a job, now you don't have a job, and as long as you earned more than $5,000 last year, then you can apply for CERB. But there's also, John, potentially severance owing right here.
Yeah, I remember you told a story, I remember this, and it stuck in my mind several years ago about a client you had who just started a lengthy contract, a nice one, a fat contract, and they canceled it a couple months in. They had to pay the whole balance of it, and it was a big one.
So that situation stuck in my mind too, because you don't see that very often. It was a 3-year contract, and about 2 or 3 months into that contract, company says, unfortunately, we're not going to need you anymore because you've only been with us a couple of months. We're going to be nice and give you 1 week's pay. Guy comes to see me, and I'm like, wait a second, this is a 3-year contract. They owe you another 21 months, or sorry, 61 months, whatever it is. Holy cow, that is a significant amount of money, and it took me a while to make the company understand that they have to pay it, but of course they did. So you may not be in that extreme a situation. Oftentimes I see a 12-month contract and a company lets you go 9 months into it. Fine, but they still have to pay you that balance, that last 3 months. Very important thing for everyone to know and understand.
Coming up here after a short break, non-compete clauses during COVID-19. We will tackle that. In the meantime, 1-855-821-5900. Email us help@employmentlawyer.ca. We'll get to that as we continue here. Stick around.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Anytime you want to reach out, by the way, pocketemploymentlawyer.ca is a good place to start. There's also the phone number there and access to email, and you can find out as well where we run our radio shows as well at employmentlawyer.ca. Let's get to our third call from the radio show for today, Lior.
My wife was diagnosed with cancer in November of 2017. She went through short-term disability, then went on long-term disability where the insurance company was paying her. That long-term disability ended on March the 26th, and she was deemed not fully disabled. So no more disability payments. Her employer just told her that they don't currently have a position to put her in right now because she can't go back to her regular job because of the physical limitations of it.
Wow.
Wow. What a difficult situation. Your insurance company says, oh, you're not disabled enough, so we're cutting you off. Your employer says, well, you're too disabled for your old job, so we're not taking you back. What is a person to do? Well, let's break this down a bit, John. First of all, let's talk about the disability aspect of it. An insurance company is known, unfortunately, for cutting people off before they should be going back to work. Insurance company is in the business of trying to get you off their payroll. It's a very common situation. Usually after 2 years of being on disability, your insurance company is going to say, come back to work, or you should be able to go back to work, so we're going to cut you off. Bottom line is this: if your doctor supports you and feels you can't work, you should still remain on a disability leave. And one of the things we can do is get the insurance company to do what it's supposed to, which is either to keep you on disability or to negotiate a payment that allows you to have some income. So right off the bat, that's wrong there. Now, in terms of the employer, John, if the employer doesn't have a job for the employee, first of all, an employer does have to accommodate. So if you can't do your old job, but you can do some other job, your employer has to find a way to provide that accommodation. They can't say, well, we don't want to, that's not your job, it's too much work. No, they have to accommodate. If legitimately there's nothing for you to do, they look, they try, but they can't find anything, then that becomes a termination and severance has to be paid. But if you're being cut off disability, you got to reach out, because in most cases it's not difficult to resolve. We have a whole team dealing just with that. We can get you back on disability or get you compensation. Don't just go with the insurance company and what they say. What your doctor says is really what matters.
TerminationQuestions.com. That is another place for you to ask your questions and get them answered. There's all kinds of ways to reach out. I want to get to one from Termination Questions we got recently here, Lior. Comes from Claire. And Claire says, I was just fired from work with 2 weeks' pay. The HR rep reminded me that my employment contract contains a non-competition clause which prohibits me from working for any competitor in my area for 2 years. That's not fair, especially given that's what's going on right now. Of course.
So let's look at it this way. We're going to give you only 2 weeks' pay, but you can't compete for 2 years. Yeah, does that sound fair? Yeah. Not really, not to me, certainly. Well, before we even talk about the non-compete, let's talk about the 2 weeks' pay. It would be extremely unlikely and unusual for you to only be owed 2 weeks' pay. So the first thing is, let's find out how much you're actually owed. It could be months and months' pay. Don't worry about what your employer says you should be getting paid or what your employer is offering. The law decides how much you should be getting. Not me, not you, not your employer. The law decides that. Then pocketemploymentlawyer.ca, you can find out what that is for you. Now, in terms of non-competes, let me kind of break a secret that many people don't realize. For most people, non-competes, non-competition obligations are not enforceable. Our laws, our courts have said that we don't like things that prevent people from earning a living, and that's what a non-compete does. So it's not enforceable. But just because it's not enforceable doesn't mean you can disregard it, because you may say, well, it's not enforceable, so I'm going to work for a competitor. Well, what happens if your old employer takes legal action against you? You will ultimately win, but it's still not a very comfortable situation to be in. So we can't just ignore that. So that's why it's so important, if you walk away from a job, if you lose your job, to negotiate all departure terms with your employer. Not just how much severance you're getting, but whether or not you're going to work for a competitor. If your employer really wants to hold you to a non-compete, they'll have to pay you even more severance. So this is just another reason from a long list of reasons why it's so important to get some advice if you lost your job.
So you can basically negotiate your way to better terms or out of a non-compete. Right?
Well, the employer is going to have to make a choice. If they really want this person not to work somewhere, then they're going to have to pay them so they can stay home. Right. If they don't care, then that's different. They can't have it both ways. We're going to pay you almost nothing and you can't work. It doesn't work that way. The law is going to protect the employee, and what I just said, that situation would simply be wrong.
We are done for another show. We hope you enjoyed it. Thank you for your time. You want to reach out now that we're wrapping it up. 1-855-821-5900. You can always go to pocketemploymentlawyer.ca. Fantastic website. You can reach out there as well. It's completely anonymous and free. And the email address to send those along anytime is help@employmentlawyer.ca. Appreciate your time. Remember, everything you heard, we'll be back again to do it all over again on the Employment Law Show. Take care.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.